Good morning, friends. It is in continuation to my earlier lecture on nature, definition, and scope of criminology. Kenny has classified criminal science in three branches: criminology, penology, and criminal administration. Criminology has been further subdivided in criminal biology and criminal sociology. Criminal biology, as we have seen earlier, that is to say, it studies physical characteristics and relates it with the criminal behavior. On the other hand, criminal sociology studies the effect of environment on criminal. Penology, we know it is the study of punishments. Criminal law, in fact, implements the policies of criminology and penology. The term criminology was coined by French anthropologist Tony Pard in 1879. During 18th and 19th century, the emphasis of scholars like Beccaria and Bentham was on reforming criminal and criminal law. Dr. S. William Catherine, in her book on criminology, says that criminology has a long and fair history, but most of the developments have taken place with the beginning of 20th century. In 1909, a conference on criminology was held at Northwestern University in Chicago, wherein it was resolved that criminal treatises available in foreign languages should be translated in English. A committee of 5 jurists was set up for completing the task. In India, the teaching of criminology began in 1940 at Jail Officers Training School at Lucknow. In 1949, a diploma on criminology was started by Lucknow University. Thereafter, the subject was introduced in many universities. For example, Tata Institute of Social Sciences, 1954. University of Sagar, 1959. University of Madras, 1965. University of Karnataka, 1970. At PG level, also it was introduced at Lucknow University, Gorakhpur University, and Institute of Social Sciences, Agra, between 1950 and 1970. In 1961, an institute was set up, National Institute of Social Defense, and in 1971, it was replaced by the Institute of Criminology and Forensic Science, which at present is also working at Roni, Delhi. The growth of criminology chronologically is identified by three branches: conservative criminology, that is to say, criminal law is given and it studies traditional criminology. Liberal criminology, emphasis on modern trends, liberal treatment to criminals, etc. Then radical criminology, it is also known as Marxist criminology. A question often arises whether criminology has independent existence, separate existence, or it is dependent on other disciplines. It is said that since criminology derives its data from sister disciplines such as sociology, psychology, economics, etc., it cannot be said to have independent and separate existence. But the argument does not hold much water because all the disciplines are interdependent, relying upon the data of each other. Secondly, it produces its own data for the purpose of study. Importance of interdisciplinary approaches need not be overemphasized in the field of social sciences. Its nature is just like science of medicine. There, the cause of disease is diagnosed and treatment is provided to patient. So there is disease and patient. Here there is cause of crime and treatment of criminal. So relationship of criminology is same, or nature of criminology is same as that of science of medicine. Now a question arises how the criminal law originated. There are mainly four theories which Professor Sutherland has described. Criminal law is taken as an instrument of social change as well as it is a dominant means of social control, and therefore it plays a dual role in society. A classical theory, the rational process of unified society, customs, conflict of interest. These are four theories which explain the origin of criminal law in society. According to classical theory, the criminal law originated in torts. In beginning, every wrong was a wrong to individual, private injury. Later on, in course of time, some wrongs were regarded as injury to state or group of persons, public injury. The punishment was provided for such public injuries. It was based on vengeance. So the punishment provided for such public injuries was based on vengeance, and therefore in those days retributive theory etc. were more dominant. Professor Sutherland says that theory is indeed inadequate as very few crimes have origin in torts. Second theory is that the criminal law originated in rational process of unified society. When a wrong was committed or is committed, the society takes action. It makes a rule to prevent the repetition of such act. A statute which is passed to do it is an expression of such emotions. If something occurs which upsets a group, that group goes to the legislature, requests that such act should be prohibited. It is obvious that some laws have developed in this way, but all laws cannot be said to have developed on the theory of rational process of unified society. The third theory is that criminal law originated in customs or mores. Customs developed with little or no ethical foundation or rational basis. After persisting for some time, they acquire ethical value or recognition. Reaction to violation of such custom, such ethical values is expressed in the form of criminal law with penal consequences or sanctions. Criminal law has developed also in this way. Professor Fuller says that the theory has substantial truth insofar as development of primitive law and modern law is concerned. The last theory or fourth theory is that criminal law developed due to conflict of interests between different groups in society. When the interest of one group is secured with the help of statutes, it is in conflict with the interest of other group or groups in society. A state is simply an interest group or coalition of interest of groups. The behavior of the rival groups thus becomes criminal in its eyes. The basis of three theories, custom, torts, rational process of unified society, is based on consensus theory, whereas conflict of interest theory is based on conflict theory. Criminal law, thus, or its origin is explained in this way. Professor Sutherland has also taken up one more question. Who is criminal? A question arises, who is criminal? The obvious reply is that the person who has committed and has been found to be guilty by the guilt finding process of the society. Criminologically, a person is criminal if he has committed crime, even if he has not been punished by the court of law. Because we know many such persons. There are words known to police, that crimes known to police, unsolved crimes. Similarly, there is justification in employing words like unapprehended criminals and criminals at large, according to Professor Sutherland. Another question arises, how long a person should be treated as criminal? The obvious answer is that once the sentence is over, his status in society is restored, that is to say, he ceases to be criminal once he completes the term of sentence. This may be a legal view or this may be a view, but this is not true, because in society there is tendency that if someone has committed crime, the people treat him as criminal for life or very long period. This comes in the way of rehabilitation of such persons. Thank you. The question arises, what is the importance of criminology? The branch of criminology has theoretical as well as practical importance. Professor Sutherland says that the criminology is concerned with immediate application of the knowledge of program of social control of crimes. It is concerned with the implementation of criminal policies in society. By studying criminology, lawyers, judges, social workers, etc. may perform their duties more efficiently and effectively because they understand what could have been the possible cause of crime and what should be the punishment to reform the criminal or to have deterrent effect. Thank you.